Good morning, Your Honors. My name is Paul McAdoo. I represent the appellant in this case, Jose Marcus Perrusquia. I'd like to reserve 4 minutes of my time for rebuttal, please.
4 minutes?
Yes, sir.
All right, so you may proceed.
What I'd like to do with my time today, in addition to trying my best to answer your questions, is briefly discuss the facts and then dive into the questions of statutory construction related to why the DA is a records custodian in this Public Records Act case, why the exception to the exemption that was asserted by the two defendants requires disclosure, and then, should the court agree, the proper remedies and whether or not reasonable costs, including reasonable attorney's fees, should be awarded. The basic facts are these, and they are undisputed, that my client requested footage from both the DA and from the Shelby County Sheriff of an incident involving a Memphis police officer kicking and punching a restrained detainee in the head after that individual spit on the officer. The sheriff recorded that video, investigated it as a possible assault, and then referred the matter to the DA for possible prosecution. The detainee actually pled guilty to assault, and the DA decided not to prosecute the officer. The DA then returned the material rather than keeping it, and it was a copy from the sheriff, but rather than keeping it, they returned the material to the sheriff. So when my client made the request to the DA, their response was, "We don't have it." The response from the sheriff was, "It's exempt," despite an exception to the law providing otherwise. And so with that kind of basic background facts, I'd like to focus mostly on the two questions of statutory construction. The first that I'd like to touch on is that the DA is a records custodian of those materials, of the footage, as well as the rest of the investigative file that the DA not just received, but reviewed and relied upon in making a decision not to charge the police officer. The definition of a records custodian in 10.7.503 is any office, official, or employee of any governmental entity lawfully responsible for the direct custody and care of a public record. There's no judicial interpretation of what that provision means. The trial court and the DA have argued that only the sheriff who made the record is a custodian of the record, and that the DA was not, despite the fact that they also received it, relied upon it, and reviewed it. That's inconsistent with more than 40 years of interpretations of the definition of public records, which is extremely broad and has been interpreted broadly. So this distinction that the DA only received the record, relied upon it, and reviewed it, does not make them a records custodian, is inconsistent with cases from both this court and the Tennessee Supreme Court. Specifically, we cited to the Griffin versus City of Knoxville case, one of the many Memphis publishing cases against the city of Memphis, the one involving depositions in a bankruptcy proceeding, and then a decision from this court from 1979 involving the Board of Education. All of those took a broad, expansive view of what is a public record and held that public records are ones that are made and received by a governmental entity. And so this idea that the DA has no responsibilities whatsoever regarding a record that they receive, which is part of the definition of public record, and only the sheriff is a custodian, is just inconsistent with this extensive case law from our courts. And to hold otherwise, it creates kind of an artificial distinction that only one governmental entity can be a custodian. That is not what the statute says. It says any twice, any official from any governmental entity. And it wasn't just some cursory review, which in many ways should be enough to make someone a custodian of a record, make a governmental entity a custodian of a record. But it was actually relied upon to do what the DA is asked by statute to do, and makes the DA one of the most powerful positions in the state, decide whether or not to prosecute someone for a crime. They undoubtedly keep records of those that they choose to prosecute, but there's an affidavit from Tim Beecham from the Shelby County DA's office that says it's our regular practice to return these to law enforcement. We review them, they're law enforcement reports, and we make a charging decision, and then we return them. That practice is inconsistent with the language of the Tennessee Public Records Act, the definition of records custodian, and extensive precedent on the related provision of what is a public record. It's also inconsistent with the rule of broad construction that's mandated by 10.7.505. 10.7.505, the General Assembly has instructed courts that they must broadly construe the statute, the Tennessee Public Records Act, in favor of disclosure. And that's what the courts have done. That's why the functional equivalence doctrine from Memphis Publishing versus Cherokee Children requires an analysis of public records that is expansive. And they should take the same view of the definition of records custodian. The other main piece of this issue is the exemption, or the exception to the exemption. The exemption that was relied upon by both the trial court and both of the defendants is found in 10.7.504 M1E. That provision exempts surveillance recordings from governmental buildings, but it has a critical exception that is at the heart of this particular case. That exception provides that surveillance recordings of government buildings are exempt, except segments of the recordings may be made public when they include an act or incident involving public safety or security or possible criminal activity. There's no question here on the undisputed record that there is both actual and possible criminal activity in the footage that is sought by my client. The question is does that may, the use of the word may in the exception, make it discretionary, or is it required? The trial court and the defendants argue that it gives them discretion on whether they can release a record that shows possible criminal activity. Based on both the structure and kind of the general layout of the Tennessee Public Records Act, as well as two different tests from the Tennessee Supreme Court that find that may is a more subtle analysis. More is required than just looking at the word itself. And I would point the court to, first of all, 10.7.503, which requires that custodians provide access to records unless they are specifically exempt. Generally speaking, the gist of that is if a record can be released, it must be released. And here it can be released because it undoubtedly has undoubtedly shows possible and actual criminal activity. The two tests, which are entirely consistent with the general law on statutory interpretation, one comes from Kallela versus Witt, a 1950s decision from the Tennessee Supreme Court that has been relied upon, cited to an in re estate of Rogers from this court. It says, may ordinarily connotes discretion or permission. We concede that. That is the ordinary course. And it will not be treated as a word of command unless, and this is the part that's ignored by both defendants, there is something in the context or the subject matter of the act or statute under consideration to indicate that it was used in that sense. To start with, we'd point back to 10.7.503, the definition, whether it's specifically exempt. If it's not specifically exempt, it has to come out under the Tennessee Public Records Act. It's not a discretionary act, it's a mandatory act. The subject matter component of the Kallela test really dovetails perfectly with the City of Memphis versus Bethel test. And all of these are cited in the briefs. In that case, relying upon a U.S. Supreme Court case, it says, where power is given to public officers, and this is a cleaned up quote, whenever the public interest or individual rights call for its exercise, the language used, though permissive in form, is in fact peremptory. The power is given not for their benefit, but for the public's. And then the Tennessee Supreme Court goes on to say, in all such cases, it is held that the intent of the legislature, which is the test, was not to devolve a mere discretion, but to impose a positive and absolute duty. You know, we're here on this appeal to clarify that piece. Does the exception to the exemption in 10.7.504 M1E, does it give discretion to the government to release segments of surveillance video that show possible criminal activity, or is that a mandatory requirement? And under those tests, which are essentially ignored by the defendants in their papers, show that there is, based on the public interest, the context, and the subject matter of the statute, the may in that provision should be required to be interpreted as a command, not as something that is discretionary. And that's entirely consistent with the general rules of statutory interpretation. We cited to Lee Medical Center versus Beecher. And because these words are known by the company they keep, courts must also construe these words in the context, just like the Kallela test, in which they appear in the statute and in light of the statute's general purpose, exactly what it's talked about in Bethel. And there's no doubt that the Tennessee Public Records Act is in the public interest. The cases are extensive on that point, and we would ask the court to reverse the trial court, find that the DA is a records custodian, that the may there is a command, and enter the other relief, including ordering release of the records, the requested injunctive relief, and attorney's fees.
If it was shall rather than may, how would that change it?
If it was shall, certainly the General Assembly could have included shall there, and it would have been the same. And there's also rules about when shall is mandatory and when it is actually permissive. And I would point, Your Honor, to the next sentence where may is used again, and I think it's really should be unquestioned that this is a situation that has to be mandatory. It says in the next sentence of 504 M1E, in addition, if the recordings are relevant to a civil action or criminal prosecution, then the recordings may be released in compliance with a subpoena or an order of a court of record in accordance with the Tennessee rules of civil or criminal procedure. I don't think there's any doubt that an order of the court telling the governmental entity to release those records is a mandatory action. And despite the use of the may there, it would also be interpreted as a command under the plain language of the statute, the Bethel test, and the Kallela test.
I have one question. You finished?
Go ahead. Yes.
Okay. Did the trial court ever rule on the request for issuing an injunction requiring the DA to retain future records? What happened in the trial court at the show cause hearing is found that the DA was not a records custodian, so there's no obligation to do anything related to the record, and that the exemption applied, and the exception was discretionary. So they never reached the injunctive relief, which would have only gone into effect, of course, if we had succeeded so
on our
no
claim.
specific ruling was ever made on that?
Correct, Your Honor.
Issue. Okay, thank you. You used your initial time. You've got your rebuttal time.
Thank you. Appreciate it.
Gentlemen, I assume both of you are arguing. Is that correct?
Yes, Your Honor, that is correct. I'll take 10 minutes, and the remaining 5 will go to Mr. Stahl, if that's acceptable.
That's Ms. Angie, can you set the clock accordingly?
Thank you.
All right. You may proceed.
May it please the court, my name is Joe Leibovich. I represent the appellee defendant Floyd Bonner in his official capacity as sheriff in this case. Appellees are asking that this court affirm the Chancery Court for the 30th Judicial District at Memphis and find the appellees had no duty under the Tennessee Public Records Act to turn over the video in question that was taken inside a secure area of the Shelby County Jail. I will not be addressing any of the issues related to whether the DA should be the custodian of a record. In essence, our argument is a very simple one. May means may. It's the plain English of the word. It's interesting in the argument we just heard, emphasis placed on the court should apply the plain English meaning of any. If we're applying plain English, we should apply plain English. The Tennessee Public Records Act states that the custodian of public records shall, and I'm emphasizing the word shall there, promptly make available for inspection any public records not specifically exempt from disclosure. The test is not if it can be provided, it must be provided. The test is that unless there's an exemption, it must be provided. Here there is a relevant exemption. And the legislature has not been shy about these exceptions to the public records request. There's, according to a 2018 study by the comptroller, there is over 500 of them. So this is not some rare unicorn that the legislature has put into place to allow public entities to not disclose documents. The exceptions that are relevant here relate to 504M1. The statute states that information records directly related to the security of any government building shall be maintained as confidential and shall, there's that word shall again, shall not be disclosed, shall not be open to public inspection. The legislature in 504M1 used the term shall and shall not. That's important when we look at the exception in 504M1E, where the legislature said that surveillance records shall not be disclosed except where, except segments of recordings may, and I'm emphasizing the word may there, segments of the recordings may be made public when they include an act or incident involving public safety or security of or possible criminal activity. So this case hinges on whether the use of the word may means may in plain English. There's no indication that is not the case. In the Colella case, the Tennessee Supreme Court held that may ordinarily connotes that it's permissive, unless there's something within the statute itself that would give indication that that is not the case. There is no such context here. The legislature chose to use the words shall and shall not throughout the Tennessee Public Records Act. Why would they have not used the word shall for the exception if they intended it to be mandatory? From the text of the statute itself, it is clear, or at least it's certainly inferable, that the legislature intended to use shall when it used shall, and intended to use may when it used the word may. So this was a permissive use or a permissive exception in 504M1E. Although the Act, as pointed out, does state that the Tennessee Public Records Act should be interpreted broadly, that's absolutely true. However, it's subject to the exceptions, and the exceptions are not subsumed by the general broad statement in the statute. That was in the case of the Tennessean versus Tennessee Department of Personnel. It's an unreported Westlaw case that's cited by the district attorney in their brief. Furthermore, there are this was not an arbitrary choice by the sheriff's office to not release these records. The sheriff's office relied on an affidavit, affidavit or affirmation by Assistant Chief Jailer George Askew that explained those reasons. He indicated that the footage could alert people to the location of security cameras within the jail, that provide an opportunity for people to see where they could hide contraband and weapons, which have been issues in the past, he stated. It also indicated the indicated footage could show security blind spots. So this could cause disruption to jail operations. It's a proper use of the exception. There are detainee privacy issues as well, because there are other individuals involved. We didn't get to the question of but it was mentioned, so I wanted to address that very briefly. The Chancery Court did not address fees, and that is clearly within the discretion of the Chancery Court. It's not appropriate, in other words, for this court to, at a first impression, decide whether or not attorney fees should be granted. However, that being said, if the court were to disagree with my position on that, the analysis of whether or not fees are appropriate is whether or not there was a willful disregard of the law, essentially. Was there a bad faith refusal to turn over documents? In this case, that's not the case. It should be noted that the Sheriff's Office turned over documents related to this very incident. They just withheld the video because of the exception to the law, to the TPRA. So the Sheriff's Office submitted other documents and it felt that handing over of the video was not mandatory, subject to the exception in the TPRA. The trial court agreed with this interpretation. It would be hard to argue that this was a bad faith refusal by the sheriff's office. Fees are not appropriate in this case. I have some time left, but frankly, I don't have much more to say. If there are any questions, I would be happy to entertain them from the bench.
I see none. Thank you.
Okay, thank you, Your Honor.
Good morning, Your Honors. Michael Stahl for Steve Mulroy in the District Attorney's Office of Shelby County. This is not a complicated case. The Chancery Court properly concluded that the District Attorney's Office had no obligation under the Tennessee Public Records Act with respect to a record of the Sheriff's Office to which petitioner sought access. The District Attorney's Office had merely reviewed the record, returned it to the custody of the Sheriff's Office, and there is no obligation in the TPRA for every government entity to retain, copy, keep everything that they look at, whether it be reviewed under a particular program or whether it be given to them for a indeterminate period of time and then returned. In any event, the Chancery Court properly concluded that the Sheriff's Office record was not subject to disclosure under the Public Records Act for the reasons that my co-counsel just went through, and I won't repeat those. The petitioner's argument fails for a number of reasons with regard to whether or not separate governmental entities are required to retain another governmental entity's records. The first is that there is no case law that says the TPRA requires that. The TPRA is specific and direct in its language that the correct custodian for a governmental record is the one who has direct control and custody over that record. This wasn't even an instance where you could say the DA's office had created the record and it was in the hands of someone else. This was a record that was created by the Sheriff's Office, controlled by the Sheriff's Office, was given to the DA's office for review purposes for a short period of time and returned to them. The impracticality of petitioner's position cannot be overstated. There are numerous examples, as the petitioner and as our briefs have talked about, we have a very liberal Public Records Act. So in this particular instance, we're talking about documents. But public records extend to sound recordings, phone messages, e-data, all sorts of things. So every governmental entity that reviews anything from another government entity, whether it's the DA's office, the Attorney General's office, a board, whatever, any time that they would be asked to look at something that had been created and controlled by another government entity under petitioner's interpretation of the Public Records Act, every single time that happened, every single other government entity would be required to copy that and hold it as their own record for an indeterminate period of time. The impracticality of that is, like I said, cannot be overstated, and it's not the intention of the Public Records Act. The intention of the Public Records Act is to give access to public records through the appropriate records custodian. In this case, that's the Sheriff's Office. It was requested. The Sheriff's Office used its discretion in applying an exception that prevented the disclosure of the video, and that's where the analysis ends. I have a minute left of my time. I'll be happy to take any questions.
I see none. Thank you.
I may return this to them. Your Honor, I'd like to obviously address some of the things that were said. The sheriff, on behalf of both, is essentially advocating for an absolute rule that may always is permissive. That is just not what the Tennessee Supreme Court has found. The Tennessee Supreme Court has found that both the analysis of may and shall is a more nuanced analysis. It has an ordinary meaning, but then you have to dig a little deeper to get there and make a final decision. And here, the context, subject matter, and purpose of the Public Records Act suggests that the may in 107-504 M1E is mandatory. It is not an ordinary permissiveness.
Mr. McAdoo, let me ask you a question.
Yes.
So as I understand your argument, you are asserting that the provisions of Section E basically override any of the provisions of M1A through D.
So I wouldn't necessarily go so far as to say it overrides. It's an exception and exemption. M1 is directly related to the security of a building. Then it says, and that includes, and it goes down a list. So it has a list, and we get down to E, and it's about surveillance recordings. And so surveillance recordings generally are one of the examples that's provided as what's included in records that directly relate to a building. But the exception is there for a reason. The General Assembly provided for that exception. So in that limited circumstance, when there's surveillance video, so if it's got to be surveillance video first, then it's got to be show possible criminal activity, and it's only that segment that comes out. That exception should be required. And one of the reasons that it's kind of highlighted by the affidavits that were put in this case, and why that's important, that it's mandatory, is government's not going to give this up unless they have to. They say in their affidavits, both sides, that we wouldn't have given this up even if, if they didn't even review it. Their affiants didn't review it, but they said, and the DA said, we wouldn't have given it up even if we had it. And then you heard the kind of the cavalcade of horrors that could happen if you release jail footage, right? All of them are potentials, cans, possiblies, potential, and they are general statements that come out of, from a jailer who sounds like would never release any record, any video from the jail. And but it's important for the public to understand what's happening in government. Sometimes that means understanding what's happening in a jail.
So your argument is that the video footage should be released regardless of whether there might be a security risk or any of those things that are enumerated in A, B, C, D prior
Yes.
to the Section E?
Yes, because it's the most specific provision. It specifically applies to this instance. And so, yes, because the exception to this in this list applies, it should be a mandatory release.
Thank you.
Yeah. I know my time is waning. Exceptions are certainly not subsumed within the broad discretion. They should be narrowly construed, though. That's kind of two sides of the same coin. We've cited cases from other states on that. The Court of Appeals, of course, has discretion as to whether to award fees for the work in this court, not the trial court. That is something that can be done. That was discussed in the Conley decision that's cited. And the Friedman decision from this court actually reversed a finding of non-willfulness, remanded to the court, not for exercise of discretion, but for entry of fees and calculation of fees alone. And that's what we asked the court to do here: reverse, order release, provide the injunctive relief, and order reasonable cost and attorney's fees, because neither side engaged at all with a definition or the tests that the Tennessee Supreme Court has had on the books since the 19th century on how may should be interpreted. If there are no other questions?
Yeah, let me ask you on this issue about the DA being a records custodian. When you look at 107-503, it really talks about the government entity that's lawfully responsible for the direct custody. Would that be the DA, or would that be the sheriff?
It would be both. So the sheriff unquestionably made it, but the DA received it, and therefore they have a legal responsibility to maintain that record. Like, they could not have just destroyed that record. That's what records disposition authorizations are for, right? So it's both of them. And the impracticality argument that we heard, yes, they'd have to keep records. It's not willy-nilly. They have to keep records consistent with RDAs. That's subject to 107-509. So there are records for, there's paperwork and decisions made on how long you have to keep voicemails, how long you have to keep emails, how long you have to keep files related to criminal cases. And so it's not, the impracticality that they're trying to sell is really not what it seems. If there are no other questions, thank you for your time.
Thank you. Thank you, counsel. We appreciate your argument. We will attempt to get you an opinion as quickly as possible. May be dismissed. Sandy, we're going to take a brief recess. We'll be back, and if you'll have the next case.